Section 26 of the Labor Act 11 of 2007. This section deals with maternity leave. So a female employee who has completed 6 months continuous service in the employment of an employer is, with a view to her confinement, entitled to not less than 12 weeks maternity leave, calculated as follows. Before her actual date of confinement, she is entitled to commence maternity leave 4 weeks before her expected date of confinement or giving birth, as certified by her medical practitioner. And she is entitled to maternity leave for the entire time from the commencement of her maternity leave, as contemplated in paragraph 1, until her actual date of confinement. So basically, one needs to have worked for at least 6 months to qualify for maternity leave. And the number of maternity leave that one is entitled to is 12 weeks, of which the 4 weeks, one may take them before the date of giving birth. And the rest of them can then be taken after giving birth. So, after her date of confinement, she's entitled to 8 weeks maternity leave, which is the rest of the weeks after taking the 4 weeks before confinement or before giving birth. In the case of an employee whose date of confinement occurred less than 4 weeks after the commencement of her maternity leave, the amount of additional time required to bring her total maternity leave to 12 weeks is then taken. The employee must provide the employer with a certificate signed by a medical practitioner confirming the expected date of confinement before taking maternity leave and the actual date of confinement on her return from leave. So this means that before you go on leave, you need to provide your employer, and it says must. So it's mandatory that you provide your employer with a certificate from a doctor indicating when you are expected to give birth. And when you come back, you must also provide another certificate showing when you actually gave birth. During any period of maternity leave, the provisions of the contract of employment remain in force, and the employer must, during the period of maternity leave, pay to the employee the remuneration payable to the employee except the basic wage. So your contract of employment, the conditions and the terms thereof still apply even when you're on maternity leave. All those confidentiality clause, all those rights to payment. So basically the only part of your employment contract that doesn't apply to you when you're on leave is basically doing work and coming to work during the expected working hours. But otherwise, the rest of the terms actually apply to you. You still keep your confidentiality while at work, your loyalty and everything else that is expected from you as an employee. So the Social Security Commission, established by the Social Security Act of 1994, which is Act 34 of 1994, must, during the period that an employee is on maternity leave, pay to that employee such portion of that employee's basic wage as may be prescribed in terms of that act. So the Social Security actually provides for the portion that it will be able to pay you while you are on maternity leave, because during that time, the employer is not entitled to pay an employee, but they are rather paid by the Social Security in terms of the Social Securities Act of 1994. An employer must not dismiss an employee during her maternity leave or at the expiry of that leave on any ground contemplated in Section 34 or any ground arising from her pregnancy, delivery, or her resulting family status or responsibility. You cannot dismiss someone just because now, I see you have now 5 kids and I don't even see how you're going to raise them and still be able to do our work. So an employee must not do that. Subsection 5 does not apply, meaning the prohibition to dismiss an employee during her maternity leave doesn't apply when the employer has offered the employee comparable alternative employment. If the employer has actually offered you perhaps a new position which is either the same or given you any other offer which does not amount to dismissal, then in that case it doesn't apply. Or she has unreasonably refused to accept that offer. So if you have been given an offer which is reasonable but you have decided to not accept it, the dismissal does not apply to a person. The dismissal in terms of Section 5 then does not apply to a person who's on maternity leave. Thank you. That's the end of discussion of Section 26 of the Labor Act 11. Let's discuss, let's engage. Thank you.